right now. First of all, I want to thank everyone for getting together on such short notice. I'm Henry Jackson, the Chief Executive Officer of the Cape Cod Islands Association Realtors and the Cape Cod Islands Realtor Multiple Listing Service. I want to thank a few people who really had the leadership and vision to put this together. First, and you'll be hearing from her at the conclusion of this program, about Lynette Helms, 2010 Cape Islands Association MLS President. We also have another director in the room, David Callahan, who came here from Nantucket. He's also a broker owner from Nantucket who serves on the board of directors. And I'd be remiss if I didn't recognize Barry Mott, who's sitting up front. Barry actually chairs the Education Committee and Task Force that puts together these Lunch and Learn. That was part of Lynette Helms and the Board of Directors vision to have two-way communication with you and inform you about salient, relevant information, such as the Massachusetts new data security law. Just to let you know the format, if this is your first Lunch and Learn, typically the format of the program is there'll be a couple speakers today. Each of them will speak about 20 minutes each. Then they're going to open it up to questions. Your questions are relevant and salient to the conversation. Hopefully when you leave here, all of your questions will be answered. So we're here to provide you communications and information. Then when that counts, we'll open it up for other types of questions and just conversation to help provide better quality, Tiffany level member services. So without further ado, I'm going to introduce our two speakers. Emulation is the greatest form of flattery, and the two gentlemen I'm about to announce definitely deserve the flattery, because Mike McDonagh, who is the Associate Counsel of the Massachusetts Association of Realtors, is a very, very bright professional, did a webinar on this new Massachusetts data security law. And then the other gentleman is Bill Menahan, who was very, very generous, also willing to come down and work with us. He does IT outsourcing. He's the president and CEO of A Networks Inc. in nearby Hingham. So if you have any needs for IT outsourcing, Bill is one of the gentlemen that you might want to consider talking to. So without further ado, I'm going to turn it over to a good friend and colleague, Mike McDonagh from MAR. Mike, please.
The leadership and staff of the Cape Cod Islands Association of Realtors for inviting me down here for this program. I'm very impressed with the turnout. I've been told there's over 100 people here. It's very impressive. Hope you have a very nice lunch. I'll keep my comments fairly brief, and I'll turn the program over to Bill after about 20 minutes. Again, my name is Mike McDonagh. I'm Associate Counsel with the Mass Association of Realtors up in Waltham. I know many of you...
Hey, can't hear you. Louder.
Okay. I'll speak a little bit louder.
Yeah.
Can you hear me now?
Yep.
Okay. My name again is Mike McDonagh with the Mass Association of Realtors up in Waltham. I've been with the association for about 9 years now. Happy to work with all of you on various risk reduction issues over the years, this being one of the latest. So again, I'm going to speak for about 20 minutes on some of the legal points of this the new regulation. We'll turn it over to Bill, who will address some of the technology and the computer issues. Then we'll have time for Q&A at the end. And the PowerPoint works. Okay, so the goals of today's presentation, overview of the new regulations, and we'll talk a little bit at the end of the program about the federal red flag rules. Not quite as important as what the focus will be here is on the new state regulations, and then some guidance on complying. So the question is, why Massachusetts and why now? What is going on with these new data security regulations, and how do they affect real estate brokers? That's really why we are here today. And what steps can you take to ensure compliance? We're looking at about a week and a half away from March 1st, which is the date these new regulations will be implemented and become effective. So the answer to the question, TJX. So about 3 years ago, there was a fairly large data security issue with TJX. You may remember reading about it in the newspapers where millions of credit card numbers were lost or stolen by a computer hacker, a professional hacker. Many accounts were hacked into, and there was an awful lot of money that TJX needed to spend, somewhere in the millions of dollars, to correct the situation. Now, TJX wasn't the only instance of data breach. There were a number of other fairly large, fairly public instances where there was a large amount of data, private data that was breached. Boston Globe, as an example. I think what happened with the Boston Globe, there was a Sunday edition that was being mailed out, and they typically wrapped the Sunday edition in some kind of recycled paper. Well, as it turns out, that recycled paper had account numbers and credit card numbers for various subscribers. So it was a mistake, it was an error. It happened. And so there was a few other instances like that. So Massachusetts becomes somewhere about 40th or 42nd or so state in the country to enact data security regulations. So we're not the only state. We're a little bit behind the trend. I think most states are already moved in this direction, but we're now joining the rest of the country with regulations. So as you can see, it costs TJX millions to fix the situation. I will say, in the almost 10 years that I've been with the Association of Realtors, I have never seen or heard of a data breach or data security issue with a real estate firm, real estate company. Let me say that again. I've never heard of a data breach issue at a real estate company. That's very important, I think, for everybody to take away from today's program. These regulations were enacted as a result of frequent and very large data security issues. But when you look at the types of companies that it was happening to, for the most part, it was large institutions, banks, lending institutions, or retail institutions where thousands and thousands of transactions occur every day or every week or every year. When you look at a real estate company, not that many transactions, it's not that many instances where you're collecting the type of information that these hackers are seeking. So when the state regulated, their goal wasn't to regulate real estate brokerages. Of course, brokerage companies were encompassed. Every company that does business in Massachusetts that falls under what we'll call in a few minutes personal information falls under the scope of the regulations, but focus wasn't on brokerage. So please keep that in mind, that data security issues are not typical issues for real estate brokers. And so in 2007, 2008, Massachusetts passed a statute dealing with the issue and directed the Office of Consumer Affairs, which is the parent state agency of the Board of Registration for Real Estate Brokers and Salespersons. They directed that Office of Consumer Affairs to issue regulations pursuant to the statute to flesh out some of the details and some of the requirements for the new data security policies that they were enacting. Addressed three major areas: was data security freezes, security breach, and just data destruction. We're going to focus mainly here on number 2, which is the security breach issue. So I was wrong. It's the 39th state requires the Office of Consumer Affairs to adopt regulations designed to safeguard personal information about the residents of the Commonwealth. So it's residents of the Commonwealth. Anybody who lives in the state falls under the direction of these regulations. Anybody who does business in the state falls under the scope of the regulations. If, and this is the big if you collect personal information. We'll talk about what personal information is in just a minute and some of the ways that you can look at your own office to figure out what type of personal information you collect. So the regulations, like I said, are set to go into effect on March 1st. They've gone through various iterations, and as you can see here, they were originally issued in September 2008 to become effective in January 2009, delayed again. And now the date is March 1st. We don't believe there's going to be any further delays at this point. They would have notified us at this point, this late in the game. So you can count on March 1st as the date for implementation. But it's important to recognize, why do they go through so many different changes, and why do they delay them so many times? Number one was because there was a lot of pressure put on the Office of Consumer Affairs by the business community to give more time to comply, number one, and number two, to be less stringent, to relax the regulations somewhat, to be a little bit easier for small businesses to comply. And that's part of what your state association did in lobbying the Office of Consumer Affairs, was to take into account those smaller businesses that don't have the same resources for legal or technical computer experts at their disposal, don't have the resources to go out and hire those people to help them. So that's what we did, and the final regulations do take into account some of the resources of small businesses. And that's what we call the risk-based approach. So it's based on the size, scope, the type of business, the amount of data that you're storing, the amount of resources that you have available. So if there were ever to be a security breach, the Office of Consumer Affairs would take a look at what type of resources do you as a company have available to you when you were implementing these or complying with these regulations. Well, we recognize that you might not be a multi-million or billion-dollar company like TJX that has all of these resources at your fingertips. You might be a small 2 or 3 person real estate firm on Cape Cod. And so those are the types of things that were included in the regulations to make them a little bit less stringent and more easily complied with by folks like you, who might not have the same resources available, and at the same time might not have the type of personal information that the state is seeking to protect. Certainly real estate brokers do come into personal information from time to time, but it's not going to be for a lot of you on a regular basis. 2 components that we'll talk about. One is the Written Information Security Program. That's one of the requirements. On March 1st, you have a WISP, a Written Information Security Program. And that WISP is basically an office policy as to how you will comply with the regulations and keep personal information secure. The second part is the technical stuff, and I'll let Bill talk about that because he knows a lot more about that than I do. Basically, to make sure that you're encrypting data and keeping your computer system safe and reasonably threat-free, like firewall, virus protection systems, things like that. So does the law apply to real estate agents, real estate brokers, and salespersons? It does in those instances where you collect personal information. When you read the regulations, it says that it applies to any individual, business, or government agency that owns licenses, maintains, or stores data whose unauthorized access or use is capable of compromising a Massachusetts resident's personal information. Wow, I almost fell asleep reading that. So what that basically means is if you collect personal information, you fall under the scope of these regulations and you're required to, number 1, have a Written Information Security Program, or WISP, and number 2, take those steps required that would ensure that your computer systems are reasonably safe. So what is personal information? It's somebody's first and last name along with somebody's driver's license number, social security number, or financial account number. And financial account number can be the credit card, debit card, or bank account number. So when you talk about real estate brokerage, what are the instances where you come across personal information that would bring you under the regulations? Well, I guess we are on Cape Cod, and people do rentals on Cape Cod, right? So when you look at the rental application, there's typically going to be a line for social security number, right? So that's probably going to be one area where a lot of you, particularly in this area of the state, will run into personal information and will be required to comply. So what steps do you take to comply when you have personal information? What do you need to do with that application? Well, the regulations don't give you specific direction, but they give you some examples. Number 1 would be to keep all your files that have this personal information in a locked file cabinet, where somebody, only those who are required to have access have access. So not everybody in the office has access to those files. One other option would be to redact or to put a black line through the social security number after the application is processed before you put it into the file. That way, now you don't have personal information on that application. So there is another reasonable step that you can take. Or maybe shred it. Maybe you don't want to shred it because you want to keep it for the file, but if there's no reason that if if your policy is that you don't keep those forms, then just make sure it gets shredded, and that way you're not maintaining or keeping that information on file. So I think there's some very inexpensive, reasonable steps that you can take as far as the rental application is concerned. Another area that we hear about often is short sales. Brokers who work in short sales oftentimes are required to get a lot of personal information for sellers, especially if they're going to be working directly with the lender to try to get approval. So those are instances where you might have a lot of paperwork. Some instances I've heard brokers say, everything that we fax over to lender, they want us to write the person's name and social security number, or name and account number on every piece of paper. So keep that in mind, because if you're working in short sales, it's probably more of a likelihood that you'll run into personal information. And make sure you either keep those files under, in a cabinet that's locked, or redact that information after you don't need it anymore. These are the types of reasonable steps. There's no set, here's the checklist of 1, 2, and 3 that everybody has to do, because everybody's office policy is going to be different. The types of transaction that you work on is going to be different from the next office. So there's no uniformity. There are probably other examples. One example may be a personal check. When you take an offer or a P&S, good faith deposit is often going to come from a personal check to the buyer. That personal check typically has either a routing number or a bank account number on the bottom, right? Personal checks, and a name on the top. So that technically could be deemed to be personal information. So I think the same holds true. You keep a copy of the check, typically you put it in the file. Well, maybe black line approval account number. That's not something that you need. I guess one of the suggestions is to take a look at everything, your office policy. Take a look at the types of forms that you use. Are there instances where you don't need to be collecting personal information and you are? Does the P&S that you use have a line on the top for a social security number? If it does, consider not using that. There's no reason in a purchase and sale agreement to have the buyer or the seller's social security number. There's just no reason. So if there are cases where you are collecting that information, reassess whether or not it's something that you need to take, or that information is something you need to take. If it's not, don't do it. And these are the types of suggestions that you can think about between now and March 1st. If you haven't already developed what we call the WISP, then these are the types of things that the state would see as relevant to having in your WISP. It seems to me that the regulations sort of crept up on us a little bit. You saw on the screen that the state has been working on these since 2008. There have been various regulations, or various versions of these regulations. When we wrote an article in our magazine up at the State Association back in the summer last year, that article, about a month later, was out of date because the regulations changed. It's very frustrating when you're working with a group of regulators who can regulate, but then change before the final implementation date. We don't want to give anybody false information, because if they change, then we don't want members spending money to develop a list or to hire people like Bill to make sure that their computers are secure, when then the state will turn around and change. So it's, we're okay with that. Bill likes the business. Bill likes the business. But I guess the point is, when you're working with the state regulator, it's very difficult to put your finger on what the final product is until they say, here's what it is, and here's the final date, there's going to be no changes. And so March 1st is the date. So what has to be in your WISP? The state has issued a model WISP. It's very good, and it's available on the state's website, which is www.mass.gov/OCA. OCA stands for Office of Consumer Affairs. If you go onto their website and click on Identity Theft on the homepage, there's a link there, and you can find a sample small business plan. And we encourage you to use this as the basis for your WISP. If you haven't already, if you haven't hired somebody to do so, you want to do it yourself. There's nothing wrong with doing it yourself. The state model is good, but it does need to be personalized to meet the needs of your own office. There are companies out there who specialize, law firms who may agency out there that will specialize in it. They'll say, we'll write the WISP for you, and that's fine. But the state has issued a model policy, a template, if you will. It's very good, it's thorough, it takes into account all of the specific requirements in the regulations. So in theory, if you take what they've given you, personalize it to your own needs, and really pay attention and change it, don't leave it as a boilerplate and put the name on top, but actually take the time to read through it and make changes and add things that you think are relevant, then that's a good first step into having your own risk in your office. The website, it's www.mass.gov/OCA for Office of Consumer Affairs. You could also get the link on our website, which is www.marealtor.com. Yeah, the link, it's on the back. This information that on the handout is posted on our website, and you can find all of those additional items up there. There's also, in addition to the WISP, there's also a checklist of, here's 10 or 20 items that if you've taken these steps, you're in compliance. Checklist, so to speak. Very good to have. So what does the WISP actually require? I'll just run through this very briefly before I turn it over to Bill. Designate one or more employees to maintain the program. Basically, somebody in the office who's going to be in charge. In many cases, might be the principal, the broker of record. Identifying and assessing reasonably foreseeable internal and external risks to security, confidentiality, and integrity of records. So ongoing employee training, employee compliance, means of detecting and preventing system failures. So you can read some more. I guess what I'd say about these regulations is that they don't really add anything new to the legal field out there. If somebody is a victim of a data breach instance, they can always sue, regardless of whether these regulations are in place. If a company, a real estate brokerage or a bank, any company were to have a data security issue, they could be subject to a claim for negligence or some other type of claim. What these regulations do is place an affirmative responsibility on every business in Massachusetts that collects information, the personal information, that requires them to take these steps to make sure that there is, or to minimize the risk of a data breach. So, to the extent that these are new and we only have 2 weeks before March 1st hits us, I mean, they're not adding an awful lot of new risk or liability to you as a real estate firm. They're requiring you to take some reasonable steps to ensure that you're keeping personal information safe, but they're not adding any new claims or causes of action for consumers who were damaged or hurt in the past. There is also a notice requirement, not to belabor the point, but if there ever is a data security issue or a data breach, there is a notice requirement. Basically, you give a notice to the State Office of Consumer Affairs and the Attorney General's Office. 93I is the companion piece of legislation which goes along with this. It requires destruction of data. So if you are taking those steps to destroy information that has personal information, put it through the shredder, redact. I don't know if anybody has a furnace in their office. You can burn it, I suppose. There is also, the final point here is there's 93A liability. In theory, if somebody were to have a data security issue, there's a possibility that the Attorney General's office could assess double or triple damages through Chapter 93A if it's deemed to be unfair or deceptive trade practice. But I think taking the reasonable steps will show good faith that you as a company, as a firm, have taken the steps necessary to comply. Number one, you have the WISP. Take a look at the state policy on that, the model policy. Number two, you've taken some steps to ensure that your computers are reasonably safe. Number three, I think you take a look at the types of forms that you have and use in your office. Make sure you're not collecting any unnecessary personal information. If you are, reconsider it. If you are and you have to, like on the rental application, consider redacting that line at the end or keeping those in a locked file cabinet. Bill's going to talk a little bit more now about computer and technical requirements, and then after he's done, I'm going to talk a little bit more about, for about 2 minutes, on some of the federal issues, and then we'll have plenty of time for Q&A. Bill?